Humanitarian asylum is sort of the forgotten stepchild of asylum law. It can be found at Section 208.13 of the Immigration and Nationality Act, or INA, and it comes in two forms. The first is humanitarian asylum based on the severity of past persecution, and the second is humanitarian asylum based on other serious harm. Of course, as a threshold matter, in order to qualify for humanitarian asylum, a non-citizen must have established past persecution based on one of the 5 protected grounds. Having established that, an applicant may be eligible for humanitarian asylum based on the past persecution that was particularly severe or on other serious harm that may happen in the future. I'm going to discuss each of these in turn. The first form of humanitarian asylum allows an applicant to obtain asylum if he or she can demonstrate compelling reasons for being unable or unwilling to return to the country of origin arising out of the severity of the past persecution. This is sometimes referred to as matter of Chen asylum, and that's because it's based on the seminal case from the Board of Immigration Appeals, matter of Chen. In Chen, the board granted humanitarian asylum where the respondent, Chen, had suffered a lifetime of physical, social, and psychological harm while in China. Despite the fact that there was no fear of future persecution, the board held that because Chen had suffered such severe past persecution, he merited a discretionary grant of asylum. 1 year later, this was codified in the regulations as humanitarian asylum based on the severity of past persecution. The second form of humanitarian asylum was created when the Attorney General decided that the form of humanitarian asylum created by Chen might be too limiting for some applicants. The second form of humanitarian asylum requires that the applicant show a reasonable possibility that he or she will face other serious harm upon removal to the country of origin. The Board of Immigration Appeals has explained that applicants must show that conditions are so bad in the country of origin that the applicant or respondent would suffer new physical or psychological harm if removed there. Notably, this other serious harm need not bear any relation to the past harm or persecution suffered by the applicant. That is, although the applicant may have suffered past persecution on one of the 5 protected grounds, the other serious harm feared or proved by the applicant need bear no relationship to that past persecution. In fact, I think the other serious harm prong of humanitarian asylum opens up a great world of possibility for creative advocacy for practitioners. For example, practitioners might argue that other serious harm includes things like ongoing civil strife, severe economic disadvantage, civil war, gang violence, medical conditions, or mental illness. So in summary, there are 2 forms of humanitarian asylum: humanitarian asylum based on the severity of past persecution, and humanitarian asylum based on other serious harm. I think it's really important that for the benefit of our clients and for the education of judges and adjudicators, we continue to argue these forms of asylum. They're often forgotten and often ignored, and they can really benefit many of our clients.